meeting of the Harris-Galveston Subsidence District. Today is Wednesday, July 8th, 2026, and it's just after 10 a.m. in the morning. Thank you all for being here. Seeing that we have a quorum, I'll call the meeting to order, and if you would please join me with the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Item 2 on our agenda is to administer the oath of office. Should there be any newly appointed board members, we do not have anybody here today that needs the oath of office taken. We can move on. Item 3 is a public hearing on a proposed increase to the regular permit fee of the Subsidence District. I'll call that particular public hearing to order, and we will accept the comments. Do you have anything, Mike, that needs to be said in advance?
Yeah, just to remind everybody, so the public hearing being held today is receive comments on a proposed change in the regular permit fee from $26 per million gallons to $28 per million gallons. This was a change that was included inside our district, shown inside of our 2026 approved budget.
All right, and we have one person who has signed up to speak in our public hearing, Melissa Rao. If you would please, it's your opportunity to address the board.
Hi, I'm Melissa Rao. Good morning, Chairman Petrov, directors, and Mr. Turco. Regarding the proposed permit fee increase, my question is not whether the Subsidence District needs resources to operate. My question is how the overall cost burden is evaluated. I recognize the regular permit fee increase itself is relatively small, increasing from $26 to $28 per million gallons of permitted groundwater allocation. For many smaller well owners, that increase alone may not be significant. However, my broader question is about the cumulative cost of regulation, including permit fees, pumpage fees, compliance costs, disincentive fees, infrastructure requirements, and whether those costs are producing measurable reductions in groundwater usage and subsidence. Permit holders are required to forecast their future water needs. If they request additional allocation, there are associated costs with that. But if they underestimate future demand due to unexpected circumstances, they can face significant financial consequences for exceeding their permit. How does the district balance encouraging conservation while also recognizing real-world changes that may impact water demand? Many groundwater users are already paying significant costs associated with compliance, conversion, infrastructure, and surface water projects. I would like to understand what specific cost increases are driving the proposed increase. What alternatives were considered? How does the Subsidence District evaluate the cumulative financial impact of regulations, fees, and conversion costs on ratepayers and businesses? I previously submitted a PIA request asking for information on total revenue collected from permit fees, pumpage fees, and disincentive fees. The estimated charge to complete that information was $360. I understand there are costs associated with producing records, but should basic financial information, such as revenue collected from these fees, be readily available to the public without requiring a formal records request? It's important for the public to understand the total revenue being collected and how those funds directly support the mission of reducing subsidence. As we discuss conversion, we have to remember affordability. Long-term compliance requires solutions that are both environmentally responsible and financially sustainable. Thank you.
Thank you very much. Ms. Rao was the only person who signed up for the public hearing, but at this time I'll ask, should anybody else wish to speak regarding the proposed rate increase? This is your opportunity to do so, so feel free.
Just for the sake of clarity, could you say something that we just heard a lot of questions, put forth to the board, and we're limited in what we respond to right now. Would you kind of explain that for anybody that may not be familiar with all that?
Well, simply put, according to the Open Meetings Act, the board can only discuss items that are particular to the agenda, and we can't have a debate and have an interaction with people. At a public hearing, we receive comments and questions as we have, and we are free to take those under advisement, research issues as we see fit. We're not making a decision on this particular item. It's not on the agenda today for a decision, but we'll come back at a following meeting and the board can actually discuss and take action at that time.
Thank you.
All right. Seeing nobody else is interested in speaking on that particular matter, I'll move on then and close that public hearing and go to item 4 on our agenda, which is to accept comments from members of the public. And this portion is to accept comments more of a general nature. And Ms. Rowell, you've signed up again. Please feel free.
Come on.
I'm Melissa Rowell, hello again. I'm regarding, speaking on 6.1, item 6.1 on the agenda. I remember when Mr. Davis with Woodloch spoke to the board in the fall of 2024.
Ms. Rowell, we'll give you another opportunity when that item comes up, or you can speak now.
It's okay, I'll speak now.
All right.
Okay. I'm going to go ahead and start over. I'm Melissa Rowell, hello again board, regarding item 6.1. I remember when Mr. Davis with Woodloch spoke to the board in the fall of 2024 when he was here to address exceeding the permitted amount by 2 million gallons. And I went back and listened to the recording. At that meeting, Mr. Davis stated that Woodloch had been in compliance for over 23 years, and that water conservation has been important to them. And in those 23 years, they had pumped about 48 million gallons less than what was permitted. 48 million gallons less. He explained some of the circumstances that impacted the community during that period, including COVID-19 related challenges, lost jobs, and changes in household occupancy within this affordable housing community. He also stated that for the current permit year, they were on track to be under the permitted amount, and he pledged to continue serving the community while following the district's rules. When I listened to his comments, Mr. Davis was respectful to the board and complimentary of the district's work. I obviously do not have all the information considered by the hearing examiner, but I encourage the board, when reviewing renewal applications such as this one, to consider the entire picture. Compliance is important, and annual permit limits are part of the district's rules. However, I hope the district also considers compliance history, corrective actions, proportionality, and the ultimate goal of reducing subsidence. I understand the district previously evaluated a multi-year permitting concept. So my question is whether that type of approach should be reconsidered when evaluating long-term compliance history and actual aquifer impacts. The aquifer does not know calendar years. It responds to cumulative groundwater withdrawals over time. I understand impacts from overpumping cannot simply be undone, but long-term pumping history still provides important context. While annual limits and rules are necessary for enforcement, actual aquifer impact is based on groundwater withdrawals over many years. When compliance has already been restored, how does a district determine what level of enforcement is necessary to protect the aquifer versus imposing financial burdens that could affect continued service? And finally, because item 6.1 involves a residential water supply for an affordable housing community, I hope the board considers the impact of any decision, not just on the permit holder, but on the families who depend on that water every day. If a renewal permit is denied for communities such as this, what happens next to ensure those families continue to have reliable surface water. Thank you.
Thank you. I don't have anybody else signed up for general public comments, but again, this is the opportunity for general comments, and we would invite anybody who is interested in addressing the board with respect to general comments to take the opportunity at this time. All right, then that takes us to agenda item 5, approval of the minutes of the regular board meeting held on June 10th, 2026.
Move for approval.
Second. I have a motion and a second to approve our minutes of our regular board meeting from last month. Any discussion necessary on those minutes? Hearing none, I'll call for the vote. All in favor of approving our regular board meeting minutes from June 10th, 2026, please say aye. Aye. Any opposed? Motion carries. That takes us to item 6, to receive our hearing examiner report and consider denying or amending applications for water well permits for June 2026 and prior. So are we gonna take up the full report first and then focus on the Woodloch, or are we taking them all up together?
We're doing the report and then take Woodloch as listed.
All right.
Good morning. We are making the recommendations for the persons who made applications for permits for water wells. They were heard during the June public hearing. We do have 3 revised recommendations. Those are revised to the extent that in the report, it does not make a recommendation. However, we do are requesting that the board issue permits on these 3 revised recommendations. All 3 are in regulatory area number 3. They all are for renewals. The first one is Ephraim Aguilera Jr., Aguilera, has lead well number 8422. It is currently permitted for 100,000 gallons. The recommendation is that the board reissue the permit for the same amount. The well serves a machine shop located on 14647 Woodloch Lane in Houston, Texas. Then we have Saulo Manzano, Manzano, first name Saulo, has lead well 9036. As stated, this is also in area 3, it's a renewal application, currently permitted. It had a 5-year permit, 1 million gallons a year. This recommendation is for a 1-year permit, and that the permittee did not request a 5-year permit this time. It will be for the same amount of 1 million gallons for that 1 year. The well serves as a sanitary needs of steel fabrication facility, and it has stated it is the same amount that was previously located, previously granted for a 1 year as opposed to a 5-year term. I'm sorry, I said that backwards. It's actually for a 5-year term, 1 million gallons each. Then we have new NERW LLC, Area 3 also. Well, number 6534. This one is currently permitted for 1 million gallons for a 5-year. This year is for 1 year because the permittee did not request 5-year permit. It serves a salvage yard. The recommendation is that permit be renewed for 200,000 gallons. Are there any questions concerning these 3 recommendations?
Any questions from board members? Does that conclude your presentation?
That concludes my presentation on the recommendations for the June applicants. And then we'll as the Woodloch permit.
All right, do we have any questions on any other permits in the report? Then why don't we get a motion on the report, and for the record clear, that would exclude Woodloch.
So moved.
Second.
Any discussion needed? Do any board members need to abstain from any of those applications? Then I'll call for the vote. All in favor of approving the recommendations as presented, please say aye.
Aye.
Any opposed? Motion carries. All right, and then let's go into the Woodloch matter.
Okay. Woodloch MHP LLC has legal number 3606. It is regulatory area number 3. The well had a previous permit for the term of August 1, 2024 through September 31, 2025. The applicant submitted a review request for that permit on August 1, 2025. It was set for a hearing, for the public hearing in September. It did not proceed that September hearing because the permittee, Mr. Davis, Brad Davis, did not believe that he had sufficient notice. He had that hearing, so it was rescheduled for the October public hearing. Appeared that Mr. Davis appeared at the public hearing for October through council. And it appeared at that time there were contested issues. There was no agreement between the permittee and the district as far as reviewing the permit. Therefore, I declared that it was a contested hearing, and the case was reset for the parties to agree on necessary information as far as a permit, a docket control type schedule of how we proceed with the contested hearing. We were not able to come up with a agreement as far as proceeding with a contested hearing, and that parties did not reach an agreement on a date. It appeared that they were continuing to discuss, as in most cases, through where there are any type of contested issues or disagreements between the permittee and the district. The parties continued to try to discuss and make agreements. That did not happen. It was not happening, so I requested a status hearing, a status conference for the parties to appear and let me know how we were going to proceed. If we were going to proceed with a contested hearing, or if it was going to be referred back to the board. We did not make any leeway, make any progress at that, so we basically agreed that we would reset it for the parties to come up with the necessary dates for the contested hearing. On the same day or sometime thereafter, the district, the Subsidence District filed a request that the public hearing be closed, the contested hearing be closed, and that my proposal for my proposal be made based upon the general manager's proposed findings of facts and conclusions of law. That was actually filed apparently that day. It was on record, and I did not consider it that day. Subsequently, I gave notice to both parties that I would be considering the proposal for decision, and asked that they respond if there were any objections to it. I subsequently agreed and approved the general manager's proposal for decision of findings of facts and conclusions of law. No decisions, no issues were resolved in the contested hearing, because we actually never had a contested hearing. So it was subsequently closed because we did not receive, there was no one offering any schedules and no one actually wanting to proceed at that time with the contested hearing. Therefore, my recommendation is that the permit renewal for well number 3603 be denied, that the permit holder, based upon the files that are in the district's, records based on the sworn facts from the, district officers, that the permit holder owes $106,901 in penalties for the Harris-Galveston Subsidence District, that the permit holder pays the penalties before the permit for well number 3606 is renewed. There being no evidentiary hearing that was made on my point, this recommendation is based solely upon the record of the district, solely upon the applications that were submitted and any reports that were made of the district staff. Attached to the permit recommendation is the general manager's proposal for decision with the findings of facts and the conclusions of law. Would you like me to read those or what to see this time?
I think we have copies of those.
So basically, the district was, the recommendation for the permit was made, but for the outstanding, payment that is due.
Why don't you go back through the proposal for the, findings of fact and conclusions, so we have
Okay.
record well documented.
You should have been able to do that.
Do we have the ability to make it bigger?
Is that better?
Sometimes.
Better, but that's still.
First brings it over the land.
How about that?
That'll do.
Okay, skipping down to the district makes the following findings of facts and conclusions of law. Oh, you want me to read? Okay. Harris-Galveston Subsidence District issued a permit for well number 3606 for the Woodloch MHP LLC on August 9, 2002. The well was located in the district at 29.8555 meg to 95.36833 in Harris County, Texas. Under the permit holder is limited to an annual production of groundwater of 10 million gallons. During the record review of the district determined that the permit holder had exceeded the amount allocation of 10 million gallons for the period beginning August 1, 2023 and ending on July 31st, 2024, by producing 12.34 million gallons without power authorization in violation of the district rule 5.3 violation. The violation resulted in a disincentive fee owed to the district totaling $106,901. On August 22nd, 2024, the district provided compliance and settlement offer to the permit holder in an attempt to achieve compliance and resolve the violation. The district prepared a potential B credit offer in an attempt to resolve the violation. The district recommended that the permittee apply up to 3.71 million gallons of B credits to reduce the violation amount to $66,994. In the second and final attempt to achieve compliance, on September 27, 2024, the district provided another compliance and settlement offer to the permit holder. On February 13, 2025, the permit holder responded to the district's offers with the counter offer to settle the violation by paying the district $36,000 over a 36-month period, an amount significantly below both the assessed penalties and the reduced fee credit offer. On August 1, 2025, the permit holder applied to renew the permit, which had expired on July 31st, 2025. The district scheduled violation and permit renewal request on the September 9, 2025 public hearing agenda. On August 26, 2025, the district mailed notice of permit holder at the address on the file provided by the permit holder more than 5 days before both September 9, 2025 hearing date as required by Rule 7.2A. Notice was also published in Houston Business Journal, although not required under Rule on the rule 7.2A for this matter. Permit holder did not appear at the public hearing on September 9th, therefore the district postponed consideration of the renewal request and violation and continued the matter to the October 7, 2025 public hearing. Additional notice on October 7, 2025 public hearing was not required for an item continued to a later date at the September 9th public hearing. On September 28th, in abundance of caution, the general manager provided permit holder with notice of the date, time, and location on the purpose of the continued public hearing by email. On October 7th, public hearing, the hearing examiner announced a contested proceeding, designated parties to proceedings, the general manager and direct parties to confer on the discovery of procedural schedule. On October 16, 2025, counsel for the general manager attempted to confer with counsel for the permit holder on procedural schedule as directed, however, the permit holder declined to agree to the schedule. On October 17, counsel for the general manager objected to counsel for permit holders unauthorized practice of law in Texas and correspondence with hearing examiner and counsel for the permittee. On October 20th, the family issued an order requiring permit holders to retain an attorney license to practice in the state of Texas or represent himself on the matter. Permit holders counsel is not permitted to proceed. Following the October 20th, 25th order, permit holders counsel continued to make appearances, file motions, and communicate with the district permit holder violating the hearing examiner's order. Permit holder has not obtained local counsel or counsel authorized to practice law in the state of Texas and has not pursued or prosecuted contested cases before the hearing examiner. Permit holder has not paid outstanding penalty or entered into a settlement agreement with the district. Permit holder has not renewed for permit for well number 3606. General manager's proposed conclusions of law. The district has jurisdiction over the matter, Texas Special District Local Laws Code, Chapter 8801. The applicant calls to allow groundwater to be pumped in excess of the authorized amount from well number 3606 in violation of this rule 5.4 of the Texas Special District Local Laws Code, Section 8801.119, and this rule 5.48. Applicant operated well number 3606 without a permit for a period which was expired in violation of this rule 5.28, Texas Special District Local Laws Code Section 8801.155, and this rule 5.28. Because the violations are unresolved, no good faith compliance has occurred, renewal of the permit for rule well number 3606 is not warranted under Texas Law Special District Local Laws Code Section 8801.158. The district board may condition issuance of permit review on the resolution of a prior or continuing violation of this chapter or any rule, permit, or order of the district, Texas Special District Local Laws Code, Section 8801.158E, and district rule 5.2D. The district rule may require the applicant to pay civil penalty or settlement amount or take other necessary action to resolve a prior continuing violation. So as I stated, these were the proposals from the district after we were unable to proceed with the contested hearing. No evidence was presented to me as far as any violation of the parties of the permit being issued or not issued. So this recommendation is based solely upon the proposal from the general manager, which is based upon the Woodloch's file and the
So basically, you're saying they didn't appear and present any evidence.
What I'm saying, right, well, they appeared, however, no evidence was presented. There was a request for, well, it wasn't, the statement was that they were not able to appear because they had not received the initial information that they had requested. However, no information had been requested through the contested hearing because we had not set a date as far as the receipt, the request for any discovery or any motions or failure to respond to any discovery. So yes, we did not receive because apparently, that's not what happened in this hearing. I declared that it was a contested hearing because at the public hearing, it was basically confusion. Nobody was in agreement to anything. So in order to resolve those issues, I said a contested hearing. Well, I actually opened the contested hearing and requested that the parties get together and work out a scheduling order as to when they wanted to appear, what dates they wanted to be in place as far as
Once it becomes a contested hearing, it kicks it into more of a trial-like process.
correct.
And, I mean, that'd be like going to court and saying this should be dismissed because I haven't gotten any information even before you've done any discovery. So you do have an opportunity for discovery in the contested case process, right?
Right, you do have an opportunity, but I did not go into that point, we're just saying you all have not. So I'm going to close it. The district actually filed a request for a proposal, something subject to a request for something. Okay,
Do you have anything else for us?
that's all I have.
Then maybe, I have several people who have signed up, and we'll give everybody an opportunity to speak. But maybe before we do that, Greg, since this process is a little different than our normal process, maybe you can walk us through the process, so we're all on the same page.
Thank you, Mr. Chairman, members. This is, I believe, the very first ever fully blown contested case hearing in front of this board. And so I do want to provide you some background on how that process works, how it's supposed to work, and where this kind of went off the rails. As Chairman Petrov mentioned, a contested case hearing is essentially a trial. The parties are named, that happened. The parties then present either present competing or an agreed scheduling order to the hearing examiner that says, this is the period we're going to have discovery. That's going to be followed by dispositive motions. That will be followed by pre-trial or pre-trial testimony. And then finally, there will be a trial date where the hearing examiner will conduct a trial that takes however long that trial takes. They'll be taking testimony, cross-examinations. That's followed by motions based on the evidence that's presented in the trial, which is then followed by a proposal for decision from the hearing examiner. Each side has an opportunity to file objections or exceptions to that proposal for decision, and that then all comes back to the full board for a final decision. This went off the rails at the scheduling point. We were asked to do a agreed scheduling order. And instead, we went into a process of the applicant was filing multiple public information act requests, which they're perfectly entitled to do. We went through that process, we issued those. All that could have been done as part of the discovery as part of the contested hearing, but they chose to go through the Public Information Act instead, and that's perfectly okay, they have that right. But we never got to the scheduling order, we never got to set the dates for discovery, we never got to set the dates for our pre-trial motions or pre-trial testimony, and so we never had the evidentiary hearing. Now, I do want to, there are a couple of changes I'm going to recommend to you all from the proposal for decision when you're ready to hear those. A couple of those things I want to clarify some of the terminology. The contested case hearing is everything from the declaration of the contested case hearing through to the final board decision. That's how that entire process is described. The evidentiary hearing is the hearing that's conducted following discovery and following the pre-trial motions, where the evidence is presented. That can be presented as pre-trial testimony, it can be presented as live testimony or cross-examination at a trial before the hearings. So that evidentiary hearing never occurred because we never got past the scheduling process. The only evidence before the hearing examiner was the evidence presented from the general meeting. And so that's where she made her proposal for decision based on that evidence. So that's where we are today. And a couple of things I want to point out. The word penalty was used in the proposal for decision. I'm going to recommend that you remove that do not recommend or do not believe that you have the authority to penalize anyone. I think you know that there are various types of penalties in Texas. There are administrative penalties, which some administrative agencies have, like TCEQ, PUC, Railroad Commission, can simply impose a penalty. So you hereby owe the state $10,000 or $100,000 or $2 million or whatever penalty they choose based on whatever their rules say. To get to an administrative penalty, you have to follow very strict rules in the Administrative Procedures Act of how that penalty is determined and set. There are also civil penalties. Civil penalties are set by a judge following a trial. That's very different, obviously, than a criminal penalty. There are certain things that can happen that cause criminal penalties. For example, there are criminal penalties that might be a violation of the Open Meetings Act. That's totally separate matter that's handled by the criminal courts. You do not have the ability to impose a civil penalty. What we have always done is we have always said, here is your settlement offer. In this case, it's $106,000 plus. And that settlement offer is going to be based on the amount that should have been paid had the permit been issued for the amount that was actually pumped. So you're paying exactly what anybody else would pay if they were getting permission ahead of time to pump that amount of water. So in fact, it's not in any way, shape, or form a penalty. It's the fee that would have been imposed had you applied for that amount originally. So that settlement offer is simply that, is a settlement offer. Because we couldn't settle it, that left us with an open violation. Now, how you handle open violations is we go to court. Now, in this case, we haven't gone to court yet. We haven't filed suit against Woodloch. When and if we do file suit, it will be for civil penalties in the amount of between $50,000 and $5,000 per day per violation. And that's up to the district court judge to determine what those penalties will be. You might remember the case with, we had one case, I won't name the case, but we did have a case where there was a violation that went on for multiple years. We had multiple problems with trying to get the lawsuits prosecuted. We were in lawsuit with them for probably about 4 years. The civil penalty for that case would have been in around $500,000. And that's because it was a penalty that went on for multiple years, multiple rounds. And that would have been the minimum penalty in that case. It's $50 a day, adds up pretty quick. Plus whatever the attorney's fees were. This board settled that for a $50,000 payment based on, mainly on the attorney's fees that they incurred in trying to get through that point. Another matter came up, we have a utility that had a leak in their system. Apparently the leak was underneath the tree. They had a very, very healthy tree that grew up as a result of the leak under the tree. But they couldn't find it because the tree was sucking up all the water, wasn't creating a nuisance anyplace else, and they had a hard time finding that leak. But they did end up exceeding their permit and exceeding their total amount that would be incurred on disincentive fee. That utility came before us and was trying to negotiate a settlement. We did eventually negotiate a settlement with them. They did do B credits. Their total amount of the disincentive fees would have been about $170,000, and between the B credits and the amount they paid us, they paid that full amount. So this is not anything new, this is not anything different. We're not treating the Woodloch company any differently than we have any other person who has been in violation by exceeding their permit, but also exceeding the disincentive fee amount. Again, had that permit gone up for renewal at that time, we would not have renewed that permit based on the fact that they had an outstanding violation, which is why they reached a settlement and paid that settlement. So this is this very standard procedure that we have gone through with every other permitting and every other circumstance. There are different ways that you can rule, there's different ways you can issue permits. You do issue multi-year permits to some people. We only issue multi-year permits to very small permanent amounts, not the large ones. We also only issue those to people that haven't had any violations for a period of time. But those 5-year permits, 3, 4, 5-year permits, are still at 1-year amounts. You have never allowed people to save up water for some future day. There are districts out there that do that. For example, the Coastal Bend District in Portland County issues true 3-year permits. They say, here's your 3-year permit. This is how much you get to pump during the next 3 years. We don't care if you pump it all in the first year, or you pump it all in the 3rd year, or you pump 1/3 each year for the third 3 years. This is your total permit amount. We're going to judge what you've done at the end of that 3-year period. That's led to some problems because some people burn through all of their water in the first 2 years, and they come and ask for an amendment to try and get some more water on the 3rd year, and that has led to issues and problems. And when we're modeling this, and Mike can certainly go into more detail on this, but when we're modeling this, we model it based on what the annual demand is going to be for the multiple years of the model. And in order to achieve that, this board has always held everybody to a 1-year amount. And, you know, not pumping this year does not make pumping more next year not affect subsidence somehow. If you're gonna pump more in 1 year, that's gonna have an impact on subsidence with that additional pumping occurring at that time. So that's why the board's never done that. That's a policy question. That would be a rulemaking question. That would be a permit decision you would have to make for future permits. Doesn't affect anything that happens on this particular permit. I also want to point out that we have never advocated or suggested that this was done intentionally, that we have a bad actor here. I don't think that's the case. There was a mistake that was made. Certainly somebody who was supposed to be paying attention to how much was being pumped wasn't paying attention. They did not apply for an amendment ahead of time to address the overpumpage that was occurring. That's a mistake. We get that kind of mistake all the time. We have a number of these settlements coming for you. Typically, we renew the permit. In fact, did so for the Woodloch permit. We renewed their permit with the outstanding violation the first year with a condition on that permit that the violation be settled in order to be able to have that permit be good. We worked on that settlement for over a year until it came up for renewal again. Now, to come up for renewal again, the general manager has taken a position before the hearing examiner that the permit should not be renewed because they still have failed to settle that prior violation. And that's where we are today. So what are your options here today? Your options are, one, you can vote to approve or not, or disapprove, or whatever you want with the proposal for decision to receive from the hearing examiner. You can change that proposal for decision as you see fit, and again, I'm going to recommend a few changes to you, mostly in the wording. And you can also, if you choose to, continue this matter to next month, and it might be a good idea to do that just to work our way through what changes we need to make in the proposal for decision to come up with a final order. And you can also remand this back to the hearing examiner. Although if you do that, I would suggest that you are conditioned upon immediate receipt from the applicant of a proposed scheduling order. So we know that they're willing to actually proceed with the process of going through the administrative process of the hearing and have discovery, and have motions, and have a trial. The last issue of controversy is the question of who is allowed to be an authorized representative. The district rules specifically state that a person can be there on their own, or they can have an authorized representative. This board has always taken the position that authorized representative means two different things. One, it has to be somebody that the applicant or landowner or well owner has authorized, stated, I want this person to represent me. That's kind of obvious. But two, it has to be somebody who is authorized under Texas law to represent people in an administrative proceeding. Now, Texas, I'm not sure how unique this is, but Texas does have a provision that allows professional engineers licensed in the state of Texas to go and represent clients in administrative proceedings. They're not making necessarily legal argument, but they are making arguments based on the engineering or the science base around that firm. That frequently happens at TCEQ. You have waste discharge permits, you have air permits, they have frequently have professional engineers who do a lot of that work. We also obviously allow for licensed attorneys, meaning these attorneys licensed in the state of Texas, making legal arguments to present that argument to the hearing. So part of the proposal for decision that I would like to fix, I think we need to address that argument. The argument's been made that the state bar rules allow any person licensed in any state to represent their clients before Texas tribunals. That's not how I read that rule. I believe that rule is designed to allow attorneys who are working remotely to do so. That if they happen to work for a company that has business in multiple states, including Texas, that they can continue to advise that client on matters that affect their work in Texas without having to get licensed in Texas. But it doesn't allow them to appear before tribunals, before courts, before administrative agencies, anybody else, to make legal arguments in the state of Texas. I think that it's instead, and the other part of that is that if there's somebody who's licensed in Illinois, lives in Texas, and wants to continue to practice Illinois law from Texas, they're allowed to do that as well. So I think that's basically the rule change was basically trying to address remote work by attorneys who are licensed in other states to continue to do that work as they always have. It was never intended, nor do I believe it clearly states, that it allows anybody to come before any tribunal to represent as a lawyer in making legal argument before that tribunal. And one of the decisions was made here is that the Woodloch Council that they hired, who is licensed, as far as I know, is licensed in the state of Florida. It is not licensed in the state of Texas, would not be allowed to continue to make legal arguments before this tribunal. And recommended that the Woodloch company hire local counsel or have their Florida attorney get what's called pro hoc vice authority to represent people in Texas. There's a procedure you can follow to get that authorization, and none of that happened. So we still don't have legal counsel representing, as far as I know, they might be here today, but we don't have legal counsel representing the Woodloch company for this permit process. So those are your options. At this point, I think we need to hear from the applicant. I think we need to hear from the attorney for the general manager. Mr. Bobby Selecki is here on behalf of the regulatory law firm representing the general manager. And I do recommend either immediately following this or at the end of this meeting that we go into executive session to discuss all the options we have. And so we will. On behalf of the questions.
What is your role in this contested matter?
I am counsel to the board of directors in this contested matter. I don't represent any of the parties. I don't represent the general manager, I don't represent the applicant. I have tried to keep the procedure on track as much as I can. But I'm here to provide you with legal advice. And so that's why the general manager has to have separate counsel, because I can't advise him and advise you.
All right, so when do we get to ask you questions?
You can ask us questions there, you can ask me questions in executive session.
I don't think ones I want to ask need to be asked in executive session.
If you're gonna be asking about the strengths and weaknesses of our case, let's do that in executive session.
So you have monitored this process on behalf of the district,
That's right, on behalf of the board.
and the district rules have been followed,
Yes, sir.
and the state law has been followed.
To the best of my legal opinion, yes, sir.
And this started out in a public hearing as all of these permits, including the ones that we have today.
That's exactly right.
And they no-showed, Woodloch no-showed, or they asked for a continuance, and a continuance was granted.
The first public hearing, that's correct.
And the second public hearing was set.
It was continued to the next public hearing, and you'll provide notice of that public hearing.
All right, and somebody showed up on behalf of Woodloch, or was this over?
Yes, sir.
Virtual?
Well, both.
Okay, and then somebody showed up on behalf of the district,
Yes, sir.
and then somebody showed up on behalf of the general manager.
Well, you say on behalf of the district, the general manager is the entity that is one of the contested parties in every contested case hearing. So the general manager becomes a party to that contested case hearing, he was recommended by council at that public hearing. The district, the board was not represented in that other than by the hearing examiner.
All right, and so the purpose of the second public hearing was to have a discussion about process and procedure, right?
Well, that hearing has to determine whether or not there's actually a contest, whether or not, occasionally we have third parties that come in and protest the permit. We have to determine whether or not that party has standing or whether or not that raises a justiciable issue. In this case, the only parties were the general manager and the applicant. Obviously, they both have standing, obviously, they're both raising justiciable issues, so the party determination was made. They are named parties to that contested case hearing, and then you proceed to the trial.
Okay, so at the continued public hearing and the next public hearing, there was some discussion between the parties about what the issues were that were going to be presented to the hearing examiner.
Correct.
And so it became quite obvious that there was little or no agreement on anything, therefore it was a contested matter. And the hearing examiner made that determination, is that correct?
That's correct.
And so then the discussion was supposed to be a routine discussion about process and procedure. What day are we gonna set to actually have the evidence presented and the contest ruled upon by the hearing examiner? And then before that, what discovery are we gonna do, when are we gonna do it, the normal routine matters that those of us that practice law deal with in lawsuits and that are normally
Yes.
dealt with in a contested hearing.
The scheduling order for the administrative proceeding is almost exactly the same thing as a docket control order in a trial.
Right, and so there was no agreement between the parties, even on a docket control order or scheduling.
The general manager proposed a scheduling order. There was no response or agreement to that scheduling order, and no council proposal.
Okay, so to this day, Woodloch has never submitted to the hearing examiner a proposed schedule that would govern the resolution of this matter in a contested.
That's correct. Let me also mention real quickly that part of what the rules allow and part of what that scheduling order would have done is it would have continued the existing permit. So Woodloch would have not been in violation of operating without a permit for the pendency of this contested case hearing. Because that scheduling order was never approved, there was never any temporary permit approved by the hearing examiner. The hearing examiner would approve a temporary permit up to 4 months at a time while the contested case hearing is going on, because we don't want someone to be in violation just because they contested the general manager's recommendation. And that didn't happen, so the permit expired, I think it was at the end of August, and so they now have been operating without a permit since that time.
So did Woodloch ever submit any request for discovery to the hearing examiner?
We received multiple public information act requests,
I
but
got
no
that.
discovery.
Nothing was submitted to the hearing examiner. Instead, they exercised their legal rights to make a public information act request.
That's right.
Did the district provide the information that they requested or that we were legally obligated to provide?
I'm saying that that's disputed. The district says, yes, they did. They did request clarification from the Attorney General about what they were required to do. They answered that. They were required to present everything the Attorney General said that they were required to present. There is still a list of things that the applicant is disputing that he never received.
But the applicant made no request to the hearing officer or the district to produce anything?
No.
Okay. So, and then, did the applicant respond to the general manager's proposal, proposed findings of fact?
The applicant has objected to it, but has not presented a counter set of proposals or findings of fact included in the law.
Thank you.
Yes, sir.
Counselor, you said earlier, I thought I heard you say that the $106,901 was not a penalty, it was a disincentive fee, is that?
That's the amount of the disincentive fee that would have been applied had they applied for that permit before pumping that amount.
Okay.
And so that would be a settlement amount.
Is that a penalty or is it a fee?
It's a fee.
Okay.
It's actually a settlement offer based on the fees that would have been paid had there not been a violation, had they been under permit for that amount.
So it's not a penalty?
It's not a penalty, no.
Well, that's what the hearing examiner
I
said.
think we need to fix that in
Yeah,
the final decision.
it was a little contradictory.
Yeah.
what was the basis of the district's counter offer of 56,000, which when I did my little calculator, it came up to right at half? What was the basis of that counter offer?
So, how, let me ask,
You may want to answer
so,
that.
so in that particular location, the regulatory plan allows 20% of your total water demand to come from groundwater. The rest of it comes from alternative supply. In the case of no, alternative.
Can you turn that on, please? I couldn't hear what he was saying. Go ahead, I'm sorry, Mike.
Oh, sorry, so that's fine. So in that particular, in that regulatory area, permit fees are allowed 20%, and then the rest of it come from alternative water supply. They exceed 10 million gallons of that alternative water supply, which is what happened in this case. So if you, you're able to use fee credits, water conservation credits, you use it for 30%, so that's why you get to that 50%, number, because you had 20% from groundwater, 30% from the fee credits, and the remainder of that is permit fees, disincentive fees.
And
But we would still have to turn the B credits to get them.
Yeah, you have to earn B credits to be able to get that.
And according to my handy dandy little calculator, the offer from the permittee of 36,000 was almost exactly 33.
No, that was our offer to the permittee. The permittee's last offer to us was to pay the amount that we do for regular permit fees with nothing toward the disincentive fee.
Okay, I thought that they offered to pay 36,000.
No, sir.
Okay, I misunderstood.
No, sir.
Okay.
And none of the offers that they have presented to us included any B credits.
From a legal standpoint, is the permittee allowed to use an out-of-state attorney to represent them in this matter? In your opinion?
In my opinion, and I would say that in order to present legal argument before any tribunal in Texas, whether it be this body, the Brown Conservation District, TCEQ, or any trial court judge, that person has to be licensed in the state of Texas.
And how do you enforce it?
Well, the way the attorney's going to enforce the jury says we're not going to accept any argument from an attorney not licensed in the state of Texas. And if that person not authorized to represent an applicant for this body.
But they continue to make themselves,
We
present themselves as a representative.
I'm gonna say generally yes. Again, because not much was happening before the hearing examiner. There wasn't a whole lot, there weren't motions or things filed with the hearing examiner from that attorney. There were a number of public information act requests, but those are perfectly legal. You can be from Bolivia and send a public information request and we have to respond. So, yeah, we answered those.
That's all.
Okay.
Back to the 106,000, that, again, that's a number that we came up with in the same way we do with all of these matters. It was the idea of trying to get people back into compliance.
That's correct.
Paying what you would have paid if you had paid it when you should have paid it.
That's correct. Absolutely correct.
How much would the V credits have cost?
We don't know. Those are open market. Yes, ma'am.
Just a clarification, so they had already owed the district money before we renewed for the first year, and they were working on paying that down.
Well,
There was a
they had
big
exceeded their permit amount.
Mhm.
Board renewed their permit at the previous, at the amount they had requested, which was less than 10 million. But included a special provision requiring them to settle that violation, one way or another,
Okay.
okay? There was no attempt to pay anything back.
Okay, so they never attempted. So can you clarify on the findings of fact, the item 9, the 36,000 over 36 months, was that for the previous? Was that?
That was an offer, my understanding is that was an offer from the district staff to Woodloch, that we would settle the overall violation with a payment plan over 36 months. And, but they also had to do the V credits in order to cover the remaining amount between $36,000 and $107,000 that we should have covered. yes, we would pay for the total amount of fees due based on the amount of water that's passed.
Okay, we might need to clarify this in the front might be.
That's one of the things I think we need to fix.
Okay.
Yes.
Okay.
Right.
Yes, yes, sir.
What happens, they're operating now without a permit, what happens if they?
We're gonna have to settle that violation. Now,
So the clock is running on this.
the standard procedure for this district, we set that violation by having them pay the amount that should have been paid, having them properly permitted. So that, you know, as long as they don't go over 10 million, that's gonna be a pretty easy settlement. They'll basically pay their permit fees, you know, plus usually a minor amount to cover the staff time and cost that we put into this. If it's not settled, then at that point, we're gonna end up having to file a lawsuit. If the lawsuit is filed, then we'll be seeking $55,000 per day for every day it's operating without a permit. Plus $55,000 per day for the prior violation. Any other questions? Okay, again, my recommendations, we'll hear from the applicant, then we hear from the council for the general manager, and at some point we have an executive session. Thank you, appreciate your time.
Excuse me, if I may, based on the information that I received from the district, the permittee did make a count offer of 36. That's the information I received based on the records that I reviewed. And it was my error to say it was a count as opposed to disincentive. But I do believe that based upon the record, there was an offer, a counter offer or a settlement offer.
I trust her on that one.
And then that's item 9. So as it's specified there is for.
All right. Well, then, let's do as our general counsel suggests, and we'll hear from the applicant, from attorney for our general manager, as well as from the public that signed up. We have, I guess, Mr.
My name is Kyle Fawad, and I
Mr. Fawad.
represented Woodloch here. I'm not here to present legal arguments. And I would like to start off by going under oath. Because unlike everybody else here, I would actually, really put myself to the test here by everything, stating everything under the penalties of perjury. So therefore, I, Kyle Fawad, declare that everything that I will state from here on will be made under the penalties of perjury. So let's start with some corrections. Number one, regarding the the Texas Public Information Act request, they have not been satisfied. And I provided a list of outstanding items that are fully disclosable that the Texas office, the Texas Attorney General's office, had ordered to be produced, but are still outstanding, more than a year later, in violation of the felony statute, actually. That's what it is. And the reason we ask for these records is because we are convinced, and we actually have some records, that goes to show Woodloch should have never been issued this fine.
Sorry, I didn't understand that, what you said?
We requested these records
Right.
long before the contested hearing started. April 29th, I submitted a long list of items that were fully disclosable. And I submit, and I can see that some of these items, in hindsight, I should have asked them. It was client attorney privilege information. But for instance, board minutes, board records, there should be public anyway, and they were held from us. Took us 6 months to get them, after having quite literally, going back and forth and bickering with the attorney that was retained by the district to handle this request. And that caused that, huge delay. Took months to deal with the simplest of issues. So part of that, and the reason we asked for these records, was to know what discovery to ask for. I mean, I understand that the chairman mentioned, these are records you can ask for in discovery. Sure, fair enough. But as far as I know, there's also something called pre-litigation petition in Texas, where you can actually ask for discovery to see if you have a valid claim, or to see if you can raise an affirmative defense. And again, I'm not, expert in Texas law, but I know for a fact. And that was the main reason we asked for these records, completely in compliance with, fully compliant with the Texas Public Information Act, and they were held. And we kept reiterating, we do not know who even, can call as witness or what, set of documents to ask for until we have received these records that we are lawfully entitled to. So that's number one. And as far as the call and assertion that we did not comply or did not engage, I don't know how else to put this, but that is 100% factually inaccurate. And I have the receipts right here. Email communications, back and forth, trying to, meet and confer with the counsel for the general manager. And when I myself, quite candidly, reached out to the hearing examiner and wanted to make sure that there was no issues, because counsel for the general manager started talking about, well, I don't think you can proceed here. And I said, well, let's nip this in the bud right away. I myself reached out and wrote an email to the hearing examiner. About half an hour later, counsel for the general manager filed a motion. I don't even know if you guys call that a motion, but she requested to get email that would kick off, and not be allowed to represent Woodloch. That was on Friday afternoon. Without being afforded an opportunity to be heard, much less be noticed, on Monday, the hearing examiner ruled that I was not allowed to represent. And she actually provided more relief than counsel for the general manager had asked for. I don't want to use your names here, but the counsel has stated he can, appear here as long as he has beach, authority or permission. The hearing examiner would not have any of that. Instead, she said, nope, you're off. You can't represent in any way, shape, or form. The applicant can, Ms. Davis can represent Woodloch himself, even though she had concluded that these concern legal matters, and that's why I come here. He could represent an entity. So it was a little bit contradictory, and of course I tried to clarify this, and I submitted motions, and I also called out the fact that the hearing examiner had engaged in prohibited ex parte communication in violation of Rule 7.5K of the district rules by reaching out to counsel for the general manager without the Woodloch copy on it for myself, and talking about the scheduling of the issues and, what is it called, the pre-hearing, the pre-conference, or the pre-hearing conference. And I found that to be very inappropriate, and of course I made a point of that, but those motions asking for the disqualification, because I thought that was disqualifying enough, never responded to, much less addressed. So these are just a couple of issues. Now, as far as
Excuse me for 1 second, sir. Can I ask a question?
yes, absolutely.
So, I got the gentleman speaking Latin, so vice,
Prohibition means for this occasion only.
I understand the meaning. Did you apply for that?
Well, I reached out to the hearing examiner and I tried.
The question is, did you apply for it?
No, I didn't, sir. That's it, that's the
That's
stress.
all of them?
I appreciate it. I'm sorry for that. I'm not trying to, sidestep the question. I never had an opportunity. Of course, I would have done so, but I was terminated without a notice or a hearing and no explanation. Really. I mean, there was a ruling, but that ruling was, there's no case authority, there's no, nothing on point that made clear that, could not represent the law. Because my position the entire time was that I am allowed to, represent the law. This is an administrative hearing, it's not the judicial. And the second, there's a Texas Supreme Court ruling, they amended Bar Rule 5.05, and that's the one I believe Mr. Ellis was talking about, and I respectfully disagree with him. I think it actually gives me the right to appear without any issues, and, of course, we can agree to disagree, so that's fine. But I was never glad about it, so, that's a long answer for you. So I'm not here, again, I'm not here to litigate the matter of the merits of the case, because I'm not allowed to apparently, but I am here to clear my name, because I do not take it very lightly being accused of the unlawful practice of law. That's a crime. So no, that never happened. I defended my position, I was open and honest about it, and the permanent findings of facts, that's not actually what happened, and we can prove it. We have the objection here, we submitted numerous papers, communications, proof, records, everything we submitted got ignored. And it wasn't just coming from me, it was coming from Mr. Davis as well. So it's been an incredibly frustrating process. And as you can probably tell, it was quite a bit frustrating to sit there and having to listen to things that for a fact is not true. And I'm not here to, to get into, argument or bicker with anyone. But I can also not at the same time sit and look back, when there's a bunch of innocent people that are about to lose access to water, and I know that I have the ability and, the wherewithal to do something about it. So respectfully, I'm gonna fight this until as long as I can, until somebody gives me a reason, a lawful, like a substantiated answer that says I cannot be part of this. At that point, I will respectfully bow, but until then, I'm sorry, I have to do it. So
have you filed suit against this?
I have. That is correct, sir.
And what is that all about?
That is about what transpired throughout this whole process. Because I believe, and I have strong grounds to believe, that my rights, my First Amendment and 14th Amendment rights were violated. I was deprived of those constitutionally protected guarantees of, to petition, to speak, to pursue my profession. And it was done under the color, the color of state law. So, and I'm not trying to be punitive here, of course, but I'm gonna at the same time safeguard my rights and not stand by idly as, I'm being defamed, because again, under no circumstances have I been dishonest, clandestine, or trying to deceive anyone. I was open. It's been open book since the beginning. So one of the forms of relief I'm asking for is a declaration to be allowed to present Woodloch. Of course, if we can come to an agreement on that, I'm willing to, remove that from the side. So I don't want to talk too much more because I know Mr. Davis wants to speak, and of course, he's well within his rights. But again, I just, for the record, to conclude, we've not been unreasonable. We've tried to meet and confer. We've been denied records that we're entitled to, and I tried my very best. I really, really did, but it just didn't work out. So that's that. Thank you very much for your time. Anybody else have any questions?
With respect to the records question.
Yes, sir.
Did you file a complaint with the AG's office?
So, and I want to explain
Which is your
that.
right to do, which is your right to do, so.
We submitted a request, and then the attorney was retained, came in, did an inquiry first, which gave more time, or drag things out. I responded, I clarified why we're entitled to it, and then this attorney was submitted into the OAG for a ruling, and the OAG largely sided with us. And even after this ruling, records were withheld from us. And I kept listing items like, this should have been produced. And no, we're fully compliant. 2 months later, more production. And I kept pressing and pressing. And one of the records that is missing is absolutely key here. It's that September 9th hearing that, we were, the public hearing that we did not appear. We did not receive any notice. And it was a very simple way for us to prove that this was not, sent out this notice. We asked for mailing records, postage fees, any sort of proof of payment. And the answer was, no, it does not exist. And I simply don't buy that. And I think that if, push comes to shove, we'll get it through discovery and federal. So.
Of course, that hearing was postponed, so it's,
Well, the whole idea was, in the findings of fact, is that we did not appear, and then it was continued. It was continued, and therefore, because it was continued, the public hearing on October 7th the district did not need to provide the required notice 5 days before under Rule 7.28. 7.2. And we don't agree with that either. And I do also want to point out that the findings of fact in this report and recommendation was supposed to be sent out by certified mail. Never occurred. We don't even know what the administrative record that was closed about the hearing examiner concludes. How do you even respond when you don't even know who you're supposed to respond to? That's been part of the problem. Anybody else have any questions?
Did you say what your relationship is to the well owner?
He is my client. And he's one of the most amazing human beings I know, and I'm proud to work for him.
So you're a friend, you're an employee,
I'm his attorney. I represent him in a different matter, and as we're talking, he told me about this issue, and I said, yeah, let me see what I can do. And I tried to negotiate, it was never my intention to have this thing dragged out, so, we were never responded to, we never got any information asked for it. I tried to negotiate on faith, but that's my position. I'm sure the other side is different, point of view, but that's basically what happened.
Thank you.
Appreciate it. Anybody else?
all right.
Sure.
make a presentation?
Been a lot going on here. And I apologize, I had a little trouble talking right now. I'm supposed to have this tooth taken out, and so I'll do my best. I know there's been a lot of he said, she said on this thing, and that's always a difficult thing. In answer to your question, he's my personal lawyer, and when he looked at all of this and all this stuff started going, I was not as engaged at a real personal level. And then when they said he couldn't appear anymore, it kind of threw me in a real bad jam because I was behind. I had no idea what was going on. And this thing went from, hey, you'll have your due process and you'll have a chance to, get counsel and do what you need to do. That was on a Friday, and the following Monday, I get this letter that, well, we're going to go with the district's recommendations. I guess they were up there. I'm not a lawyer. I'm a real estate guy that's trying to do the right thing here. I made a little list because, as I understood it, this was a contested hearing, 6.1, I guess that's what you called it. And so I wanted to speak about that and then just briefly speak about the water. As far as this contested hearing, again, you guys know a lot more about it than I do, but the reason I'm here today on this contested hearing is, number one, to open the record again, and send this matter to a neutral hearing examiner that we could mutually agree to. I have, in her support, she said it was a uncontested or a non-evidentiary. And so we always wanted to get to the evidence, and that was something that colleague mentioned. One of the reasons this thing drug out so long is because the information that we're entitled to, we've never been able to receive. And we feel strongly that that would be what we need to be able to go ahead and proceed. In fact, it's my opinion, had we had that, we would not even be here today. This would have all been gone a long time ago. So anyway, I'd like to open the record again with the ability to be able to disclose records and produce, and I'd like to have the documents produced that we're entitled to. Number three, I would like to direct the neutral hearing examiner to allow discovery under fair terms so this matter can be decided on the merits rather than, the one-sided thing that's been going on. And I wrote down just a couple reasons here why, let me just read this to you if I could. The reason I'm asking for this is the hearing examiner did not follow the district rules. And here's just 4 examples, started out with engaging with communication with the general manager's lawyer without my knowledge, which they've said is a violation of 7.5. I don't know all that. I've read a lot of these rules and 8801 and all that, being involved with this thing for so long. And there are a lot of questions, no question about that. Number 2, ignored motions calling for her disqualification. We brought that up, all starting from that ex parte communication. And one of the big difficulties is never getting a response. And this is well documented. We ask for something and we get nothing. How do you deal with that? And then the same with the records. Hey, we get these records, the OAG said, give them to us, we still don't have them. What are we supposed to do? And this has been a very difficult, frustrating situation. And I just about got gray hair over it. Number 3, after asking us to prepare a scheduling order and suggested the next hearing would be 6 weeks out, after just 2 business days, she sent a letter saying she was prepared to accept the general manager's, misstatement.
Findings.
Huh?
Findings.
Yeah, findings. And so it's like, wow, this went from due process and me being able to have a chance to now I'm just shut down. So that's just a little bit about why I feel like that this contested hearing has been really not very fair. And it would be good to be able to enter evidence And we're all prepared to do that, and we would like to get what we're entitled to so that we can get to that. The second thing, and I'll be real brief, is about the water. Because really, all this stuff back and forth and these little words and all these things, we kind of lose focus with really why we're here. What is this thing all about? And what it's really all about is subsidence. I mean, y'all have done a great job over 50 years in moving the water where it went from, I think, you can correct me if I'm wrong, all groundwater, well water, to no surface water. And over the period, moving to where 80% of the water now is surface water. And you're only drawing 20% is the goals for decreasing the subsidence. So that's been great, and, you know, we're all in favor of that. So I'd just like to say, did we have that,
Yes.
deal?
You know what, let me pass it around.
The water use, like, what is it, 800, I think in 2024, 868 billion gallons were pumped out of the ground? 868 billion gallons. Our permits for 10 million. It's like a drop in the bucket, it's nothing. These numbers are so mind-boggling that I try to break it down, so I broke it down like this. If you have $868 representing the water, our little water usage is 2 cents. So for 2 cents worth of water, we're going through all these troubles, all this stuff, when really we should be getting an award for underpumping. We have been underpumping. We were permitted for 10 million, and over the last 25 years, we've averaged 8 million. Since this has all happened, we were at 8, just a little over 8 last year, and this year we'll be around 7. So our water usage is so far under what it is, and like I said, it's such an insignificant number. It just, I guess I would put it like this: the crime and the fine. How do you say that? The fine doesn't seem to equal the crime. You're driving down the highway at 55, you're going 57, and you get 10 years in jail. That doesn't seem right. And that's kind of similar to this. I mean, here we are trying to do the right thing. Our residents, we don't use water in the yards. We don't use water to wash cars. I mean, probably most people here have sprinkler systems. We don't even allow that. We keep our water usage so far back. So I guess the last thing I would say about the water is the aquifer. That's what this is all about, right? To prevent subsidence, to keep as much water in the aquifer as we can. We've been doing that. Yeah, we were over a little bit during COVID, and the people that moved into our community because they were thrown out of their apartments or whatever reasons that they were there, they lost their jobs, they would have been drinking water somewhere else. So really, it didn't go up in the grand scheme of things. It might have gone up a little bit in ours, but we're down, we're under, we're always under. And we support the district. We support everything that you're doing. We believe in what you're doing. We are your strongest advocate. And I'm here to advocate for these people that are here today because they probably use less water than we do. I'll bet you, I'd be willing to bet it. I bet you the 80 people, 80 homes in that community, 70, whatever it is, I'm willing to bet they use less water than just the board here. You know, because y'all probably have sprinklers and different things. So I get frustrated and carried when I'm not feeling good and on drugs, so I apologize for all that. I just want to thank you for allowing me to speak here today. And I would just like the board to consider everything that's going on and try to do the right thing here with this. And renew our permit, let these people go back to drinking their water, and we will continue to be good permittees as we have been. And so, you know, thank you. If there's anything, I've got this, did you pass this out? Yeah. And then there's did you see the other one that we're down so far? I mean, and we'll continue. We regardless of what y'all decide today, we're gonna continue to save water and keep the aquifer as full as we can and do the right thing. That's what we've been doing from the start. Yes, sir?
Do you charge your customers for water?
No, sir.
Okay, why not?
Why don't I charge the people for water? Well, first of all, let me just tell you that we do everything we can do to keep the prices down.
I understand.
And if we were to charge water, it would raise all of the prices. In fact, our well operator wanted to do that at one point, and it was gonna raise the prices for the community. Each individual is gonna have to pay considerably more. So that's the short answer.
Okay, you charge an individual space for rent, I presume then?
Yes,
Okay, why didn't you increase your space rent by $2 a month, or $12, or $5 a month to pay?
pay what?
Pay the original penalty to start with. I rent a utility district, I needed money, I increased the utility rate a small amount, I got the money in a short period of time. Why didn't you do this, spread it out over a 3-year period of time, you'd had it all paid for?
My permit is for,
I know what you permitted for, I'm asking.
No.
Why didn't you take the money, or the $56,000 was offered, you got 80 spaces, taken, do it about 3 years, and you had to pay for them, nobody would have been unhappy. We would have been happy, you would have been happy.
well, that's a good question, and I was told that. I was early on here, and when I came here, people said, oh, just raise the rents. And I said, look, these people, they're struggling financially.
I understand struggling financially. I live on Social Security, small 401. When my wife passed away, my income dropped by 40%, but my utility, my insurance, everything else did not drop by 40%. Normally, a pack of cigarettes is probably $10 now. How many people smoke? If you want to stop smoking, you take care of that.
Yeah, I guess there's a lot of different ways to handle it. My basic position is that the people that live in our community, I respect them. I do the best I can to keep the rents down. Or what tax increases is just another thing. I mean, all of these increases come up, gas, food, to where people are having a tough time surviving. And so, and I'm sorry for your situation and sorry for your loss. We continue to try to do the right thing by our community. And I would say that this $107,000 fine is not $2 a month. It wasn't 56, it was 66 plus B credits, which I don't even know what that was. And Mr. Ellis had mentioned that the board or somebody made an offer, it was my offer. When I came in here to meet with Mr. Turco and Mr. Jones, Mr. Ellis attended, and, Mr. Ellis said, write something up, do something, give us an offer. So I wrote up that offer that I would pay $1,000 a month for 36 months, which to me was way in excess, because I was starting to mention my permit has only cost a couple $100. And that's one of the reasons why we can keep our rents to where we do. If I had to pay an extra $100,000 every year, I mean, shoot, the place would be empty. People would be moving in with each other. And this is something that is a very difficult thing. And, I'm sorry that I don't have the money to pay, but $107,000 for somebody that's been under for so long, and for people that have been sacrificing by not washing, driving, they start hosing off their driveway to get the dust off. We're like, no, you can't do that. So anyway, we read our meters daily. Okay, if we get a daily spike, we're out there trying to figure out whose toilet's leaking. Okay, that's the kind of operation, and that's how much respect we have for what y'all are doing here. Sorry for holding myself.
When you say you read the meters, you're talking about the well meter?
Yeah, the well meter.
Individual homes are not.
We do have separate meters. We did that so that we could better monitor the usage, because with one, who's using it? So we thought, okay, we started targeting the ones that we thought were probably the big users. So we started, we're a small operation, we don't have money. So we do 10 at a time. We do 10 there, we do 10 there. And so I don't know exactly, but if not all, most are individually metered now. For our own reference.
You haven't had them individually metered, but you've gone through the process of installing them?
Yeah, for the purposes of reducing water usage.
Correct, thank you.
Yes, sir.
Any other questions from board?
Yes, ma'am.
Seems like the year 2024 was the highest, and went over the permitted amount. And it seems like we actually notified you for public hearing several times. Did you get the notifications for a public hearing?
I'm sorry, what's the question?
I was asking if you actually received the notifications for the public hearing back in 2025.
Look, I don't know. Honestly, I don't know if there even was one. I have no idea. I do know that we're quite responsive to everything that we get. We've got 2 other properties which we continue, they're real close to that one, and we're way under our permit on those every year too. Our record, you can look at our record, and we've always paid on time, we've never been late, we've always respected all of the rules and everything, and so if we get something, we respond. And that's part of the frustration with not getting all these records that we're asking for. It's like, man, the rules should apply to everybody. You know, why does it only apply to us?
Mr. Davis, just to be clear, the well is currently in operation.
Yes, sir. Yes, it is.
Right, everybody in your compound gets water, their water's flowing.
Yes.
The district has done nothing to any water.
The district has been great to us, as far as I'm concerned.
We don't have the ability to shut the water off, do we? All we can do is file suit.
We have the ability to get injunctive relief, but,
Well, we have to go back and shut the water off.
We have to go through the lawsuit process.
Yeah, we're not like a utility that can send it out and turn on.
You know, that's another thing, is we have no alternative water source. You know, I know that, again, and credit to you guys, you've done a lot to get to where there is surface water available, for other people. I know I live up in Conroe, and they run those big pipes down to Caleb, or whatever that is, to get down there to Woodlands, and that's all great, but we don't have that. We have one source of water, and we maintain, you know, if water break happens, we're on it. We appreciate you guys, and I'm not here to fight, never have been. You know, I'm just asking for a little help, you know, just asking to consider, you know, doing the right thing here. And it's not $2. It wouldn't be $2 to raise the rents, you know.
All right, thank you.
Anything else, anybody? Okay, well, thank you much, appreciate it.
All right, let's, go ahead and hear from, is it, Bobby Salemi?
Good morning, Chairman and Board of Directors. My name is Bobby Salahi of Graves Doherty here in Moody Law Firm in Austin, Texas. We represent the General Manager in this proceeding. I want to provide a brief overview of some of the main points in this case. First, I do want to clarify that no ex parte communications ever took place. It's a very serious allegation against our firm, so I want to make that clear. The facts are, first, Woodloch violated the previous permit and district rules about overpumping. They applied for their renewal after the violation already occurred and hadn't settled that violation when they had done so. Woodloch refused to settle that violation, and instead the matter proceeded to that contested case hearing. Woodloch failed and outright refused to follow the administrative procedure for a contested case, leading to the hearings examiner remanding back to where we are here today. We could have agreed to that procedural schedule, which we sent over. The discovery process would have been part of that. The information that they claimed they requested via Public Information Act could have easily also been obtained via discovery. The general manager agrees with the recommendation of the hearings examiner to deny the permit renewal for well number 3606. We recommend that the permittee pay the penalties that are owed for the overpumping that occurred. The general manager and I are here to answer any questions that you may have on this matter. Thank you.
All right,
shed some more light on the Public Information Act status. I realize they could have asked for discovery and apparently it's undisputed that's what happened with the hearing examiner. So they submitted a Public Information Act request to the district.
Yes, sir.
The district ended up sending that to the Attorney General's office for the Attorney General to look at the request and determine what the district was obligated to provide. Is that right?
That's correct. I believe the district provided some of the things that they had requested at that time. And we sent it for an Attorney General's opinion. My firm was not counsel for that request. I believe the district counsel, outside counsel, handling those requests. That said, we provided everything that they requested. Certain things the district doesn't have. We can't create things and provide it to them if they don't exist. For example, the records of things that we mail out. We mail out the notes. We don't have it, so there are no responsive documents. They don't like that answer, so they're saying we'll withhold. For us, they might not like that. We're not producing in native form things they may be requesting. Either they don't exist because of their formulas and spreadsheets. I know they wanted the fee calculation that Mr. Jones puts in, and some of the things that they want don't exist. And we provided them the format of their requests that they don't like, so they're saying we didn't respond. That's really where we are now.
So did they follow up with the Attorney General's office complaining about the response or the non-response of the district?
Not to my knowledge.
We did.
And that was their agreement, to go back to the Attorney General and say, hey, Attorney General, you ordered the district to provide X, Y, and Z.
They filed C, right.
Enforce your ruling.
We did do that.
Yep.
If I could, because this is outside of investigative hearing staff of the Public Information Act. The process when you have a Public Information Act request is you file a request. If the agency, the government entity, has questions about whether or not this is material that's required to be released, they can go to the Attorney General and request whether or not it has to be released. That happened. There was briefing filed by both sides about what the information request was released. AG ruled, provided an opinion. The district, to my knowledge, followed everything in that opinion and released all the information that would be required to be released. The next step after that would be to file a suit against the district for violation of the Public Information Act, claiming that they had not followed the Attorney General's response. That did not happen. Any other questions from Bobby or Jessica? Yes, ma'am.
Question, so has the permittee, have they denied that they went over the permit limit? That they
I don't
violated?
think so. No,
Okay,
ma'am.
so they haven't denied that they violated the permit. Is there any information that they've requested that would show that they didn't violate the permit?
Not that I'm aware of.
Okay. Thank you.
Are they complaining about the calculation?
I don't think so. I think they just don't like the way it was calculated, and they think that there's maybe something natural that's discovered, but our formula is sound, and we provided actually, the spreadsheet that Mr. Jones uses. So we showed the numbers and how we calculate them.
And it's based on gallons pumped and the fees associated with that, all public information, right?
Yes, sir. Yes, sir.
When did you become the general manager's attorney?
Thank you.
That's an excellent question. I don't know when my firm was retained, but we have an engagement letter with the.
Which is
district.
unexecuted.
We've been doing work for the district for many years. My co-counsel, Natasha Martin, had been representing, she couldn't be here today, but she had been representing the council, the general manager, and this was the beginning for this matter. That's the question.
Okay, I just didn't realize we had that relationship going on out there.
Yes, sir.
It's an odd situation when you get into a contested case, because Greg is the board's attorney, so, and since we're the decider, it would be inappropriate for Greg to also be making the case at the examiner level. outside counsel to handle that and see if Greg can give us an independent people. Any other questions?
Mr. Chairman, may I please make some clarification statements?
No,
Sir.
you've had your opportunity.
Sir, they're operating under an unexecuted legal service agreement. It was never signed off on.
Okay, thank you.
I want to clear it up for the record.
All right, we have a few other people who have signed up, and I'd like to give them an opportunity to speak.
Thank you, sir.
Mr. Timothy Ferguson, would you like to address the board?
Hello. I just want to make a couple of points. Knowing the facts that these parks have been running 7 million gallons, the permits have been set.
Can I ask you a
Yes,
quick
sir.
question? Are you a resident of?
No, I'm an employee. I do maintenance.
Okay, thank you.
Yeah, no problem. So, been operating grossly under the permit level. So for 1 year to have exceeded during COVID times, unpredictable. Everybody understands people were doing a whole lot more washing, a whole lot more cleaning during these times. So I do find it, I ask for a little leniency here, just for that, knowing that, that the, what do y'all want to call it, a penalty was just the verbiage right there. If it's not a fee, or is it a penalty or is it a fee? Well, it's not a penalty, so where does this fee come in? And when was it established? There's a lot of miscommunication between the two. I feel that something could have probably been agreed upon way sooner if there was a better communication between the two. That's just my given opinion about it. I ask that y'all vote fairly towards the decision of this. And just keep in mind that there are a lot of lives and a lot of others affected by it, all of it. So that's all I have.
Thank you very much. And then I have Joyce Cersei. Would you like to address the board?
I'm not going to get this. Just bear with me. First off, during this time, and right after COVID and before and during, like I said, they're wanting to do an extra cleaning after everything. And I do believe that we've had new managers that have had to come in and learn the system and learn how to take the numbers. And sometimes they need a little bit of leniency. I know I took it over, I didn't get any, training, you might say. But sometimes we don't know. And what we don't know shouldn't really hurt us as much as it did. The people are working with us real good. And just, if you make a mistake, and that's what this was. Everybody makes mistakes. But there are so many people that are gonna have to pay for this thing. Because, like you said, just raise the rent $1 or $2. What $1 or $2 did you want to raise? Medicine for the kids, food, lights. These people don't have any. We're trying real hard to keep our rent and everything low enough. Most of them came to us homeless and off the street. They don't have no extra. So, even if when you go to court, that's why you commit a crime. First time offenders are usually treated differently. Now, if we've done it before, or if it was repeat, I would understand this. But it's not. And it hasn't been done since. So, in my opinion, it could be overlooked, or at least have some argument. But please don't look at our people to get the money. They don't have it. They really don't have it.
Let me ask you a question. How long have you been living there?
Almost 10 years.
Has he increased your rent in the last 10 years?
We don't,
I'm asking you a very simple question. In the last 10 years, have you had a
I am a
rent increase?
manager of another park.
The what?
Manager to Miller. And mine are in the same condition as his. They don't have money.
I didn't ask that. I asked if you had your rent increased in the last 10 years.
They have, in his. Now, I do not, in my part, if you've lived there 10 years, you have not had your rent increased. When you move out, if that building is worth more now, then the rent will go up. I do that because they can't afford a raise. If they could, they probably wouldn't be living in ours, because we do everything that we can to keep ours affordable. We like to keep people off the street.
Do you own the trailer or does he own the trailer?
No, I'm a manager, I live in the office.
So you live in the office then?
I do not pay rent,
You don't pay rent?
no.
What about your other people that do not live in the office? Do they pay rent?
So,
Yes.
well, wait a minute, you mean our workers?
No, you said it has,
Tenants,
80 spaces or 80 trailers there?
Woodloch does,
Uh-huh.
and
Do
yes,
the
they
people-
pay rent.
And they pay rent?
So just out of clarity, are you an employee of Woodloch or are you?
I'm the manager over Miller, but I help with Woodloch a lot.
She manages another property and doesn't live on the Woodloch property.
That's right. But we're all united.
Appreciate your comments. Thank you for being here today.
And then, we also have, Anna Rose, signed up.
My name is Anna Rosas, and yes, I am the manager of Woodloch. When we got Woodloch, there was a lot of things that were not right. That the water was one of the main ones, and that's the topic that we're here today. Ever since then, we found out that we went over. Right away, we got on it. Right away, as you can tell, the numbers of the evidence, we work constantly very hard to comply. I especially, like the owner said that we got meters, that was one of the things that came out of him, to do the right thing, to comply with the state, right? So these meters, in each individual, and we go by the size of the family. You know, we're not gonna put a meter right away on a house that has one person. So if you have a household with 7 people, you're gonna get a meter. So I believe we have 60 meters now out of 80 trailers. It's very costly, not to mention he had to hire somebody to read the meter and do the math on it. So it's not just get it done like this. So this system has been working. And what happens here is when you go over, the paper goes to the general manager and then it comes to me. My job every day, if somebody goes over the limit, I have to go and knock on the door and let them know you have gone over. There's consequences, there's action, to the point that we got here. Right now, I have the tenants scared out their mind because they know what we're doing right now, the owner and myself. You all have the decision to make whether we get the permit or not. I feel after reading all the records and all that, we have complied, like Ms. Joyce just spoke, that maybe out of that one time, there was an error. We all make errors. But I can tell you that as the manager, we will continue to work hard. I myself have been in that trailer park for 27 years. I raised my children there. They're high school graduates, and I have seen many attendants there with their kids there. It's not a violent park, so a mistake was made, but we're working hard on it. And I take pride. I call that my trailer park. Mr. Davis can say it's not, but that's my trailer park. When I got there, I saw things that I could do. I didn't get paid for it, but it's my community. I stepped up, I lived there, I loved the schools. It was a step up for me. I love the schools there. I took it upon myself to let's make it better. Like I've said, I've been there 27 years. I have kids. There were kids that were small, now they grew up, and the parents are still there. When I told them what was about, and we got a short notice, I do have signatures. I was only able to get like 33 of them, of people that asked you to have mercy on them. These are older trailers. If Mr. Davis does not get the permit, I can guarantee you that these people will be lost, including myself. Okay? So whatever it takes for us to comply, we'll continue to comply and hope this all works out for everyone. This will work out. I myself, my children ask me, when am I going to move? I said, why should I move? I mean, I raised you guys here. I can open my window and I can see where my child played and was raised and went to middle school, high school, and now they're gone. You know, my memories of it's just not a trailer park and it's just not a job. This means something to me every day. Every day that I get up, and I'm a prayer person, I pray about everything and worry about nothing. So I'm not going to worry about this situation. But I do ask you to have mercy and let's do the right thing. Consider that how many people it's going to affect. And most of all, that you would have our word that we will keep the water. Like I said, we don't have swimming pools there. People don't wash their cars. Everyone knows that there's a limit to everything. And you have a certain amount of water you're going to use, please comply. I'm only one person that goes around and we look, but now we have other people, other neighbors that help and agree that, hey, if your neighbor's wasting the water, say something. So I can go over there and tell them, please comply because we're under state regulations. So I just ask you to please give us an opportunity to work together in this community and we'll get it done right. Thank you for your time.
Thank you very much. So that is all I have signed up. Was there anybody else that wished to address the board on this particular matter?
Yes, sir, I'd like to say something.
So come on up and tell us your name and we'll be happy to hear it.
My name is William Brewer, and I live in the Woodloch property. I work for Mr. Davis. The mistake was mine. I was the character who was charged with keeping tabs on water usage. During that year, I was having my own personal life struggles as well as dealing with COVID, and I've got a special needs child as well that was in hospital. I'm not here saying we didn't make a mistake. What I'm asking for is during the COVID era period, you know, even our government stopped all from evictions, so there is legal, there is some provisions. And that's what I pray for you guys today, to think about. You know, during the COVID era period, people were working from home, students and children were taking school at home, so the water usage at home did drastically increase. So that's what I'm asking for today, is to take consideration of the time period, and I think you very much.
I think we're going to need to discuss this in executive session before we make any kind of decision. We want to conclude the remainder of our agenda first, or how do we want to handle that? Greg, do you have a suggestion for us?
Yes, it depends on what you're gonna do. I think that most of the folks are here to hear the outcome of this particular decision. So in this case, it might be a good idea to go ahead and go to executive session now, so that we can get that completed. They can come back in and hear the decision you made again. If you want to complete the rest of the agenda, go into executive session, that's probably okay to you, but they're gonna have to wait until after you come to executive session anyway to hear the decision.
I think we should do it now.
All right, so let's, we have a motion and a second to suspend the rules and all in favor, say aye. Deliberate this matter.
Excuse me, can you repeat? We didn't hear it. Sorry.
They're going to executive session.
Oh.
So the board of directors of the Harris-Galveston Subsidence District will now meet in closed executive session